Okay, here we go. Kevin Thompson here, doing a Facebook Live. I did a post yesterday asking for questions from the community, and I got a bunch of really good ones. These things sort of make me nervous because they're live. You can't go back and fix everything. On the one hand, they're easier than the old days because you just do one shot, you're done. On the other hand, a little bit of pressure. So I'm a little casual today. I got the sweats on, and the lighting might not be ideal, but remember, I'm a lawyer, not a marketer. Uh, for those of you that are on, just hit the like button or something. Just let me know that you can hear me. There's the love button. Thanks for the love. Okay, so something different today. Just want to start off, and I want you to think about one thing that you're grateful for really fast. I know that's not the reason why you guys are tuning in. You don't want to hear, self-help from me. There's a lot going on in the world. People are anxious. People are nervous. The Kobe Bryant news from a couple of days ago, very tragic. Things going on in politics. But just take a moment to think about, what are you grateful for? Because it's impossible to be grateful and unhappy at the same time. So really force yourself to think about something in your life that you just love. And I'll go first, really fast, top of my head. Everybody would expect me to say family and wife, and absolutely those are top priorities, but I'm grateful for a great partner. So Walt Burton, a lot of you guys don't know him, you've never met him, but he's the Burton and Thompson Burton. And to build a good business, you got to be paired up with the right people. And he's a phenomenal attorney, a great partner, great with business, and we have just the two of us over time, we've grown to 25 lawyers with a vision to go to 50 to 100 to 200. So I'm grateful for that relationship. It's very important. So all that being said, let's rock and roll. For those of you that are tuning in live, type in a question, stop me, argue with me, whatever. All right? I got your questions printed off. And I'm going to go in order. And if we're done in 10 minutes, fine. If we're done in 30, whatever. I'm just talking to myself here. Predictions for the Super Bowl. I predict 49ers by 10. The Chiefs beat the crap out of my Titans, so I'm still a little bitter about that. And I think in the Super Bowl, the favor goes to the better defense. 49ers have an insane defense, an insane pass rush. Yes, Patrick Mahomes is incredible, once in a generation kind of player. But I think the 49ers pass rush is going to give him a hard time. So 49ers by 10. I also grew up a 49er fan. One of the few celebrity moments I've ever had, I had lunch with Dwight Clark a long time ago. Okay. Nikita Maxey asked the latest on Naora. Actually, I got an update about the Naora case from Deborah Heiss. You guys will remember I did an interview with her about a month ago, a few days after she was sued. She gave a presentation at an event, the Direct Sales Legal and Compliance Summit. The title of that event sounds horrible and boring, but it was actually really, really valuable. In her presentation, she gave us an update. And essentially, the FTC hasn't done anything since litigation started. Normally, when the FTC sues a company as a pyramid scheme, just like they did 2 weeks ago, on January 8th against Success by Health, they immediately follow up for what's called a temporary restraining order. They want to get the company under an injunction as soon as possible, just to squeeze the life out of it. And in every scenario that I can think of, and that's covering a lot of space, I've never seen the FTC sue a company alleging them to be a pyramid scheme and not ask for an immediate injunction. Here, number one, they didn't ask for the injunction, and they still haven't. So we're 1 month into this thing, maybe even longer, and the FTC hasn't filed their motions for an injunction, which means, without question, I think the consensus is that the FTC was caught off guard. The complaint was messy. It was rushed. The basis to move it from Chicago, which is a 7th Circuit, to the 3rd Circuit is very tenuous at best. So the FTC, for the first time that I've ever seen, actually seems to be disorganized. So that's the update on the case. I'm kind of bullish on Naora's shot here, which actually surprises people, because when you're adverse to the government, you lose. But the FTC has been challenged in a few cases recently. There's one called Credit Bureau. There's one called I'm going to screw up the name, but Viroshire, I think, with a pharmaceutical company. And these companies have successfully pushed back against the FTC on a number of issues. One of those issues being whether the FTC can even recover monetary fines because it's not in the law. So, it's sort of been assumed that they have this power, but there's no statutory authority. So now you've got more conservative justices in the courts, and what do conservative justices do? They say, well, what does the law say? And the law doesn't say anything about monetary fines. It talks about an injunction. And so essentially these courts are saying, you know what, you need to go to Congress and get the rules changed. So the FTC is losing, and NAORA is striking at the right time. And I think they're a pretty good champion to be in this fight. They're not perfect. Nobody's perfect. No company is perfect. But, the fact that they make maybe aggressive claims about product or about the income opportunity, those aren't the kinds of infractions that would justify a complete shutdown. Pyramid scheme, yes, shut it down. But they've got significant retail sales, so the pyramid scheme argument is, in my opinion, overreach. Hopefully I'm not talking too fast. I've had a lot of caffeine this morning. Okay, Dan Malteus, sorry if I mispronounced your name. Auto ship and personal volume requirements to qualify, are they red flags for regulators? It's a very timely question. We actually just wrote an article about a month ago regarding MVRs. And I'm going to go ahead and share that with you guys. Right now, it was published December 12th, monthly volume requirements. It's time to reconsider the concept. There's the article. Now, monthly volume requirements, I want to be very clear, they're not illegal at all. And there's never been a court that said that this is indicia of a pyramid scheme. The problem is that regulators argue that when you have like an MVR, which let's assume 100 points, you have to move 100 points worth of product to qualify for commissions. And by moving the product, you can qualify via personal consumption, or you can sell to customers to hit that quota. There are some very legitimate and good business reasons for an MVR. Richard Brooke shared with me privately a lot of those reasons, and really, that's why I create content. I push content out, I get feedback. I think it gives me an advantage. There's reasons for that. You need to have predictable inventory controls, and you want the people that are doing the work to be paid appropriately. And if your lower level leaders that are just barely hanging in there, if they get a check, regardless if they're moving product or not, maybe it dilutes the pot. Anyways, there's good reasons for an MVR. The downside is it makes it easy for regulators to argue that the majority of your people are buying just to hit the MVR. So you need to have data. If you have an MVR, I recommend having some sort of retail sales requirement, something that coincides. So let's say you have a 100-point MVR, 50 needs to go to customers. That would really protect yourself. And if you don't have that, just understand there's risk. Again, you're not dead in the water immediately, but it just makes the FTC's job a little easier, because what they can do is they can dive in your data and show that, look, 80% of your distributors just get on auto ship and conveniently hit that minimum quota. They're not buying less, they're not buying more, they're hitting the quota, which indicates they're buying to qualify for commissions. They're buying for the wrong reasons, is what regulators will argue. It's called opportunity-driven demand. So it just makes a company an easier target. So I published the article to start the discussion. I think it's important. Somebody says, we'd love to hear your thoughts on companies like IML, Dagcoin, Melius. IML, I think they're living on borrowed time. I've thought that ever since they sued a guy that was deaf. We represented the defendant in that case, and it got resolved, but not the behavior of a very intelligent company. Dagcoin, probably a Ponzi scheme. All the OneCoin people seem to gravitate to DAG Any kind of coin in the network marketing space should be perceived as very, very dangerous. Okay, what excites you most about the future of the industry? Conversely, what scares you the most? This is my favorite question, right? This forces me to think. That was Dante Zampetti. Sounds like a really good Italian name. Maybe it's not Italian, I don't know. But Dante is a family name in my family. Okay, what excites me the most? D2C, direct to consumer. People are trying to figure this out. Brands in general are trying to figure out D2C. Not every brand can pay the Kardashians $250,000 for an Instagram post or $500,000 for an Instagram post. They can't pursue these mega brands to push the product. And so they're looking for a lot of smaller relationships, smaller influencers. And that's something that as an industry we should have an edge on. We've been doing this for 100 years. And the glue, essentially it's great product, of course, but it's also financial incentives. People have a reason to be ambassadors for product. That's an advantage. Now, do we need pay plans that pay just infinitely in depth, you know, where we have these million-dollar opportunities? I think the industry is transitioning away from that. And Al Bala, CEO at Manatech, really just blew my mind this weekend, and in a way where I thought to myself, why didn't I think of this? The gig economy has about 50 million people that are participating. They're driving cars, in Uber, Lyft, doing Airbnb. I Airbnb part of my basement. I have my kids do it. It's incredible. Money just falls from the sky for space that was just doing nothing for me. There's Shipt, S-H-I-P-T. There's all kinds of gig economy opportunities. These people aren't trying to get rich. They just want $200 to $500 a month in additional income. And they've got 50 million participants, people that are gladly doing it willingly. So I think you're going to see, you know, our industry, which currently only has 5 million people in the industry. Now, what did we miss? I think what we missed was, you know, we got stuck in the 80s and 90s where we offered a really big lifestyle opportunity, and that's what was presented as part of the pitch. And a lot of people don't really want that, especially millennials. They flat out don't. They're more than happy to rent. Instead, people are looking for a consistent and simple way to generate just extra income. So I think you're going to see plans pay less in depth and reward more retail sales. Maybe a couple levels for recruiting to incentivize team building, but that D2C trend, you're going to see more companies focusing on product and customer acquisition. And to do that, they're going to have to condense their plans. So that's what I'm excited about. I think that's a massive opportunity. That 50 million people in the gig economy, that audience belongs to us. What scares me the most, if we don't learn quick enough. I was just talking to my wife about it this morning. There is regulatory pressure, but I'm not so much worried about regulatory pressure. The FTC, they can't make the law. They can sue whoever they want to sue, but the law comes from Congress. And so I don't think we're going to be regulated into oblivion. I think it's competitive pressure. So companies need to innovate and sell real products that have, you know, unique value propositions that can't be found anywhere else out there. That's important, and we're lagging in that category. So that's what scares me. We can't innovate fast enough. Somebody asked about China. I can't really provide a lot of value there. What I do know is that the majority of companies that operate in China are doing it illegally, because network marketing is illegal in China. Now, apparently there's a registration process. There's a very expensive process to get approval with the Chinese government. Most companies don't do it. They go through Hong Kong, somehow get their products into those territories. It's a different animal because my understanding, very limited understanding, they don't go after the companies. The regulators go after the sellers, the people on the ground doing the work, which I think is very unfortunate. What that means is you don't see headlines of companies being shut down there, which gives companies here a false sense of security. Oh, everything will be fine. Once we're in China, we'll make lots of money and they'll sell and we'll do what everybody else is doing. What's happening is the sellers in those markets get into trouble. And again, most companies in China are doing it illegally. Aaron McInnes asked for the Direct Selling Legal Summit takeaways. Great question. So she's asking about the Direct Selling Legal and Compliance Summit put on by Momentum Factor, which is run by Jonathan Gilliam. He hates how I pronounce his name. He says it's Gilliam, Jonathan Gilliam, and he's come a long way. I'm really proud of him. He started out just doing marketing materials 10 years ago, and now he's got FieldWatch. And he's assembled just a great community of legal minds, both in-house and outside counsel, like myself. And he puts on this event. I think this might be his fourth. And it's the most valuable event that I go to every year because practitioners just compare notes and there's no agenda. You go to a DSA event, there's an agenda, right? Everything's rosy, everything's great. Let's put on Amway's guy who knows nothing about AI and let's have him talk about AI because it's good for his ego. It's all politics and it's a complete waste of time, candidly. I'm not in the DSA anymore, so I can speak freely about it. I got no value out of those events. Here, it's a bunch of practitioners, competitors, and we get to compare notes. Very valuable. The key takeaway, Aaron, was this. I'm not alone. So when I read these cases, when I read the FTC lawsuits, when I read the guidance, when I see what's happening out there, it gets a little lonely because maybe the back of my mind, maybe I'm reading this wrong, right? Maybe I shouldn't be concerned, or maybe I should be more concerned than what I am. Because there is no statute to look at, black and white. These are the rules. It's a tapestry of different things that are out there. It's the FTC gives a speech here, and they sue a company here, and they sue Nerium. And you've got these commissioners that are, 3 Republicans, 2 Democrats, so you can make some assumptions there. And, different priorities, and et cetera, et cetera, et cetera. So we formulate these opinions based on experience, but we might not be right. The main takeaway is that the analysis that I've been sharing with you guys is accurate. There's a guy that I respect, John Villafranco, and he's a lawyer's lawyer, works at Kelly Dry. It's a massive firm. He's very academic, and he's concerned. He has concerns about the direction the FTC is heading. The main takeaway for me is that I'm not alone in viewing MVRs as an issue. So the idea of minimum volume requirements, I thought, it's kind of edgy for me to push that out there because it's a centerpiece in our industry. A lot of companies have MVRs. And again, it's not illegal. But based on what I'm seeing, it does increase the risk profile. And companies need to be aware of that. They need to do whatever they can to minimize the risk if they have it. And a lot of folks just really aren't aware of that risk. Well, anyway, a bunch of lawyers get in a room, and it was a topic of discussion. So I was encouraged to see that. Another takeaway is that the 13B issues are massive. 13B is the part of the statute in the FTC Act that spells out the remedies the FTC can pursue. And 13B currently says they can get an injunction. It says nothing about disgorgement of profit. It says nothing about monetary fines. And says nothing actually about prior misconduct. So if you think about that, you get an investigative demand from the FTC. You change your business, you clean it up. Can the FTC sue for your prior sins? Some people say no. Anyways, that is a big deal in our industry because the FTC sort of their power emanates from this history of case law that is being cut back from these more conservative justices. Okay, so those are big takeaways. Somebody keeps asking me about Telex Free. I have no idea what you're talking about. I haven't heard of those guys in years. Teresa Crespo, thank you for the compliment. Tim Siebert, hello. All right. Okay. Paula Scarcella, one of my favorites. Paula, how you doing? Okay. Let's go back to my script here. CCPA. This is a data privacy bill passed in California. And my associate Thomas Ritter does cybersecurity, and he's very much involved in these particular issues. CCPA is essentially California's version of the GDPR. Don't ask me what these letters stand for, but it involves data privacy, data protection, data security. Now, a consequence of GDPR is that, yay, great, we have protections, we have regulation. The downside is that it stifles innovation, because if you're a small company, you can't afford the compliance piece. And so Google and Facebook, you know, they're clapping their hands. They've got these resources where they can comply. The small companies cannot. So that's a consequence that was foreseeable, and yet these bills pass. California, essentially, they can't regulate America, but they can regulate activity in California. And essentially, if you collect data from anybody in California, which is everybody, that's every company in the industry, you're not going to carve out California and say we're not going to do business there. It's one of the biggest markets in the world. So anybody collecting data has to comply with CCPA. You know, specifically, what does that mean? Well, it means like knowing what data is stored, having access to your data, the companies having the ability to delete the data, certain compliance standards, and I think I could be speaking out of turn. There's what's called a private right of action, meaning a lawyer, a law firm in California can say, hey, you're violating CCPA. I'm not the government, but I'm like the government. I'm going to sue on this basis. So expect a lot of just cookie cutter letters, cease and desist letters, and then eventual lawsuits regarding the compliance standards in the CCPA. Eventually, you're going to have every state having some version of this. So it's coming. If you're in the field, it's not your problem. The pressure's on the company. And if the company is using an outsourced MLM software vendor, the pressure is on that vendor to really get their act together in this category. Isagenix acquisition of Zesea, I predicted that. Smaller companies are going to get swallowed up by bigger companies. When momentum is gone, it's really hard to juice it back up. Much easier to fold into a bigger company. And when you say acquisition, don't assume that there was like a financial transaction. A lot of the founders want everybody to believe that they sold their company. Usually it's a giveaway. It's just one genealogy rolling into another. The founders or the shareholders, they get a position in the new company. Usually it's not as big a deal as it's projected to be. Excuse me. Okay. When companies go international, do they have a leeway to stretch the truth? No. But they think that they can, because out of sight, out of mind. So the American regulators have sort of created an impression in the mind of Americans, right? We see it on TV. We see Law and Order, Department of Justice. We know what the SEC is. We read the newspaper. We see the headlines. We are aware of the presence of these agencies, and we know what they can do. Overseas, there's a lack of awareness, and for a lot of people, ignorance is bliss. And as you guys know, ignorance is no defense in law. But a lot of founders go internationally and they think, oh, once we get to Hong Kong, everything's fine. And it's not. It can be a problem. Taxes, well, my advice is pay them. In the field, you get a 1099, and based on the 1099, you got to pay your share of the tax. What's deductible? Well, what products that you buy for personal consumption are not deductible. But support materials and marketing expenses, those are deductible. What's up with Amway these days? I have no idea. I don't hear anything about them. 3 biggest errors. I like this question. 3 big errors that companies do. All right, and I took notes here. One is kind of obvious. I'm going to insult your intelligence here. Hype. Just overstating the opportunity, overstating the product. It actually repels more than it attracts. That's a big mistake. lack of innovation. So they come out with one product, but that product has a life cycle. It's no longer as interesting as it used to be. Maybe you can pick it up in a Kroger now, right? It's not very unique. What's called margin erosion. Your margins shrink, competitive pressure. If people are buying just because of the pay plan, you got a problem. So companies need to innovate and create new and interesting products, and I'm seeing a lack there. The biggest mistake is they expand too fast. So young companies especially, they just don't have the enterprise yet. They don't have the organization yet internally. It's one thing to recruit a field, but you have to build a company, right? I recommend you get an office like this. You have space. I've got a partner next door, and I got a partner next to him, and I got a paralegal next to them, and I've got resources here, and we get together and we see each other and we talk. Ideas spark from those conversations, and we can delegate tasks. I always have a hard time saying that, tasks. And so companies, they say, well, we know people in Germany, and so they just go to Germany. And you get time zone differences, you have legal differences, you've got language issues, and it just dilutes the focus of the team. So what I like to see is I like to see the team domestically grow, healthy, to where you've got some human capital, and then you can say, you know what, you handle this, and you can properly delegate to other people. But when you expand too fast, the wheels can fall off. California's new gig economy law. This is referring to the bill regarding employee versus independent contractors. So essentially, Uber, this law is really designed for the Uber community, and essentially independent contractors have to be given certain employment benefits. Now, if you impose that sort of obligation on network marketing companies, that's kind of the end, right? When you recruit someone in the field to join your business, it's not an employment opportunity. You have no idea how it'll pan out. Just like when I hire a painter to paint my house, I don't want to have to worry about unemployment insurance and retirement benefits and healthcare benefits. That's why my house painted. It's performance-based. So there was concern that this bill would sweep up the direct selling industry. And the DSA, to their credit, and this is where they do provide a lot of value, they were able to negotiate an exemption for direct sellers. I mean, specifically direct sellers, network marketers. And so we are not covered in that bill. However, the concern is that as other states adopt similar bills, and in particular blue states, right, states that typically lean Democratic, where they want to advocate for employment rights, you're going to, will those bills be as precise as the bill in California? It remains to be seen. So, any further questions here? We have covered a lot of ground. Let me go through your comments here. So somebody asked, what about when owners and distributors make claims that appear too far out there, such as weight loss claims? Well, the thing about efficacy claims, meaning the performance of a product or even the performance of a pay plan, like an income claim, anytime a claim is made about performance that's atypical, you need to provide averages, period. Hello, Jay. Let's see here. Bitcoin is set for a bull run. Anything to be done about exposing the scammers that will inevitably rise? Yes, there will be scammers that take advantage of the Bitcoin bull run. The SEC is getting much better at sending, at a minimum, subpoenas to the companies that are in the crypto-related network marketing business. Actually, it's a rumor. I'm not going to give any names, but there's a lawyer that was subpoenaed due to his or her name repeatedly popping up with a lot of these crypto scams. So can't confirm it, not going to say anything specifically. There was a question about confidential investigations. I have a suspicion. This is my opinion. It's an educated guess. So the folks at New You Life can go to hell if they want to sue me. It's an opinion. I think they're under a confidential investigation. They can easily disclaim that and say that they're not. By all means, if they say it, I'll publish it here. But based on what I'm seeing, Truth in Advertising predicted that New You Life would be sued this year. That's a very bold statement from an entity that is rarely wrong. And based on the clients that we had, Patty Sinclair, I see you on here, and Georgia Hargett, that case is currently in limbo on ice. New You Life is not pushing it, which means I think they've probably figured out that one of the reasons for their troubles is their stupid lawsuit. So that's an opinion. It's a hypothesis, cannot confirm it. I might be wrong, but I sure hope they get what they've got coming to them. Okay. Jay Leisner says, anything new on the Neora cases? Yes. Start the video over because that's what we covered right at the start. Future of CBD in the MLM space. Not sure. Any comments on the attack on CBD companies by FTC and FDA? FTC hasn't really attacked CBD companies yet regarding lack of substantiation for health claims. Okay. Guys, I'm going to give you one more opportunity to ask a question. Otherwise, we're going to wrap it up. Hopefully you learned something. And if you did, share it. And remember, think of something you're grateful for. You got a lot going for you, whether you realize it or not. Chris Williams says, I'm looking great. Thanks, man. That's a wrap. Take care, everyone. Ciao. Requirements to